if you can't enforce your patent, don't file it. That's the advice from Keren. Keren, we got a question from one of the attendees. He's asking if there's an idea being worked upon on the web, but the idea on the web is not working properly. So if you make an app for it, the app can perhaps solve the issues which are not being solved on the web application. Can you patent it or can you protect it?
If you have, again, can you repeat, please?
So suppose there's an idea, there's a platform, it's a web-based application, and
web-based application.
It's a web-based application, and there are certain limitations on the web-based. For example, the thing which you can do on your phone, sometimes you can do them better on your phone on an app than on the web. So if you are doing it on the, the idea is existing on the web,
okay,
not working properly as per you, and you want to develop an app for it because you think if you develop an app, you will be able to do better things than what are being done on the web. So in that case, can you protect your IP?
So if the only difference between the web application, between the web and the application, it's just that this one is in the cellular phone and the other one is the web. So that could be obvious. It may be novel, but it could be obvious. And one of the conditions to obtain a patent that can be granted is that you have to be non-obvious. So if it's obvious to do this as an application, then that would be very complicated and if at all allowed. But in many cases, when you adopt a known methodology to another device, as may be the case here, and the adaptation itself includes changes in the invention, then you can maybe pursue protection for those small changes. So you should consider it. You need to consider and approach the patent attorney and think, maybe there is something in the adaptation itself. Maybe sometimes inventors think that small changes are non-patentable, but in some cases that says they are. So it's worthwhile to check and evaluate these small changes. Maybe these changes would be more profound. So.
Absolutely. So this is for everyone to know. Suppose you have this cup without this handle, and if you insert this handle on the cup, and your contribution is this handle. So by adding this handle to the cup, you're making this cup new. And if you're able to prove that adding this handle is non-obvious, in other words, you have a non-obvious advantage, your invention becomes non-obvious. So all you have to do is, if any idea comes to your mind, just think about two things. Is it new? Is it non-obvious? If it's new and non-obvious, you can qualify for a patent. All you have to do is, how do you prove it's non-obvious? If you have a non-obvious advantage, for example, in cases this handle has a non-obvious advantage. If I'm able to hold the cup better with better grip, I will not feel the hotness or the coldness of the cup. I will not drop the cup because I'm able to hold it better. If I'm able to prove a non-obvious advantage of any feature, any small incremental feature, that feature becomes patent worthy.